Welcome to the podcast. I'm Michael Kushner, your host. With me today is Senior Associate at the law firm MBK Chapman, Sam Kill. Sam, good morning.
Good morning, Mike. How are you?
I'm fine, thank you. Today we're going to be talking about something that is a major source of frustration for homeowners all over the state of California, and that's architectural approvals.
Oh, yeah.
Okay. I think more than any other single topic, getting your stuff approved probably ranks among at least the top three.
Near the top, absolutely.
Yeah. And so whether you're thinking of upgrading, making some major renovations to the structure of your house, or doing some landscaping or anything that might otherwise be controlled under the architectural guidelines, this episode will be for you if you're going to be doing that. We're going to walk through how California empowers HOAs to govern and control certain aspects of architectural control, and we're going to talk about the limitations of that power as well. We're also going to give you guys some tools and tips on how to push back if your HOA goes too far. We're also going to arm you or educate you, at least or prepare you for the things that they can control as well, okay, just so you know what it is up front. Now, I want to do a caveat for this episode. Solar panels and EV charging have separate statutes, and we've got episodes already dedicated to those things. So I might mention solar panels or EV charging in passing today, but for the large part of this episode, I'm going to skip those two issues just because they have separate statutes. They're a little more complex, and we've already addressed them fully in other episodes.
There's a public policy concern for those
right,
as well.
Yeah, and so we're going to leave those out, except maybe in passing.
Right.
Okay? So let's jump right in.
Okay.
Architectural guidelines, from a very basic, if you're looking at the whole forest view, are adopted by the HOA, and they're empowered almost certainly in the CC&Rs to set architectural guidelines. And they're empowered to make decisions about a whole variety of things so that they can maintain some sort of control or say on the general ethos or aesthetics,
yeah.
look of the neighborhood. And part of their job is to maintain a certain aesthetic standard. So these things usually come into play when you want to either, if you're in new construction, you want to put in your first landscaping, or if you come in later, you want to add on to the existing structure, or you want to make a major change to landscaping by adding elements or taking out. Usually going to have to go through the HOA to do that.
Right.
And now, architectural guidelines can be their own document. They're treated at the same level. When you talk about the hierarchy of governing documents, you got your CC&Rs at the top, and then you've got bylaws and articles, although articles are kind of irrelevant for the most part. And then you've got rules, and architectural guidelines are on the same place. They might actually be in the rules themselves, but they're very often separate. Okay? A lot of HOAs find it easier, and I agree. It's easier to have operating rules,
right,
architectural guidelines. And so almost certainly your HOA is going to be empowered to pass those, and those can be passed just like any rule can. 28-day notice period, comment period, that sort of thing, okay? So, Sam, let's just walk through on a real basic level some of the things that are going to be covered under almost every set of architectural guidelines.
Right. I mean, these are common exterior features and components like exterior paint, landscaping, flora, types of vegetation.
What's flora?
Well, we're talking about basically type of trees, shrubbery, landscaping elements that an association wants to, I guess, regulate and have some degree of oversight on in terms of certain prohibited items versus what's allowed to preserve a certain aesthetic.
Let's talk about trees for a second. Now, by the way, you said shrubbery, and whenever I hear that word, I think I don't want to say it. I don't want to get dinged on YouTube, but, that certain comedy troupe from Britain. And I keep replaying the word shrubbery in my mind. Shrubbery.
Yeah.
But anyway, you were talking about certain flora, trees and bushes and things like that. And some of those are actually prohibited. I know that in certain parts of California where we have really high fire danger, eucalyptus trees are going to be banned in a lot of those because they're high oil and very, very, not only are they very flammable, but they burn very hot because of all that oil in the tree. And so those things are tinderboxes. So I know that at least around here in South County, Some communities ban eucalyptus trees,
Exactly, yeah.
even though they're beautiful and they're everywhere.
Some probably like bamboo or other types of plants that attract mice or rats, for instance.
They could.
Yeah.
Yeah.
But yeah, I mean that's certainly one big area that's regulated. Another few would be things like garage doors or window installations.
Yeah, the color of the garage or the style of the garage. You can't just put, if your whole neighborhood's got wooden garages, let's say, they're probably going to balk it glass and metal.
Right.
Right.
Yeah.
You want it to look like the Bat Cave, they're probably going to balk at that. 'Cause
Exactly.
It doesn't fit. Right.
So it's a pretty extensive list. But I mean,
fences,
right? Walls. Yep.
Okay. Anything also, sheds, greenhouses, structures, especially if those structures can be seen over the wall height, right? Even and by the way, heights of walls.
Right.
Okay, that's often governed by municipal code as well. But let's say municipal code says you could have a 7-foot wall. Your HOA might say no, 6 feet.
Exactly.
And that's okay. Yeah. Lighting. We talked early on in one of our 6-part series where we talked about neighbor disputes. We were talking about one of your cases.
Right.
One of the firm's cases, but it's one you're handling with the light pollution issue.
Exactly.
And so the kind of lighting.
And that's one too, where basically they provide for a range of sub-elements that need to be checked, such as shading or what type of landscaping lighting is permitted.
Right, outdoor lighting.
Right, exactly, yeah.
Right, so as I said, architectural guidelines are often separate from the CC&Rs, and they are often separate from the rules, even though they're considered as part of the rules. Right. They have the same legal effect as rules, and they're passed the same way. There's no difference other than the topic.
In the majority of CC&Rs reference architectural requirements, and then they have a separate set of documents that boards adopt.
Right. And they'll say these are our basics,
Yeah.
and the board is empowered to be more specific, and they will do that. So in a case like that, where your CC&Rs do have specific statements on architectural guidelines, to the extent that the architectural guidelines conflict directly with what's in the CC&Rs, it won't be enforceable at all because CC&Rs are on top. They win.
That's right. Yeah.
So you don't see that a lot, but I have seen it once in a while. We do see that. Okay, so we think we've covered the basics. So let's talk about what the law requires in terms of architectural guidelines. Okay, and here we're going to be looking at Civil Code 4765. Okay, and you can follow along if you want to read that, because I'm not going to quote the statute, but that's where you'll find architectural guidelines.
Right.
Okay.
Yeah.
Now, at least I would say that's the most important statute to understanding the scope and limits of architectural guidelines. It'd be 4765. 4765. Now, above all else, that statute mandates that architectural decisions have to be made in good faith.
Right.
It cannot be, and this is the 3 buzzwords that we as lawyers love to use. They cannot be unreasonable, they cannot be arbitrary, and guidelines cannot be capricious. Don't worry, I'm going to go into painful detail about what each of those means in the law. I'm going to define them for you in a few minutes. So I'm going to give you the information you need, okay? But that's important. The number one rule when it comes to architectural guidelines, according to 4765 of the Civil Code, is they have to be reasonable, right? So they can't be unreasonable.
Correct.
They cannot be, and it's in terms of negative, right? If they can't be unreasonable, that means they have to be reasonable. If they can't be arbitrary, that means they have to be non-arbitrary. There has to be a purpose behind them.
Correct.
And if they can't be capricious, that means that they have to have some rational relationship to reality.
Right.
Okay? So let's talk about that. As used in Civil Code 4765, the term unreasonable means it has to make sense based on the situation.
Right.
Okay? And not all neighborhoods are the same. For example, if you lived in a very, very high fire zone, your HOA might have a long list of plants that are not allowed just because they don't want the danger. Really specifically very flammable plants, like a eucalyptus.
Right.
Okay? Whereas if you're in Northern California in Shasta County, let's say, and where you get a ton of rainfall, your HOA might not have any prohibited plant life because the chance of forest fire might be lower there than it is in a really dry area. It's that sort of thing. So they are situationally dependent, okay? I'll give you an example. You want to paint your front door a different color than the shade of brown that it's always been, okay? Your HOA can say, well, wait a minute. nobody else in the neighborhood has anything other than one of the approved brown shades. So you're asking for crimson. We're not going to allow that. Okay? That is reasonable. But if you wanted to paint your door a shade of brown that was similar to another neighbor's shade of brown, not exact, but similar, they would have a much harder time arguing, well, no, it's got to be these 3 shades of brown, and that's it.
Right.
It has to be reasonable, okay? Or, for example, let's say other neighbors have colors other than the approved set of shades of brown. Some people have teal, and some people have a light crimson, and you wanted a lighter or darker crimson. They would have a much harder time arguing that that they have to enforce the shades of brown when they've allowed other homes to do otherwise.
In other words, it can't be too strict without an adequate basis or rationale.
If it's unreasonable if they've selectively enforced, or it's unreasonable if they've kind of forgotten their rules.
Right.
Okay? So that's unreasonable. Arbitrary, a little bit different. And by the way, sometimes the line on these is close. Mm-hmm. Sometimes you walk on
straddles,
the line.
yeah.
That's right. Sometimes it straddles. But arbitrary is when the decision feels random, like the people in charge are just making it up as they go. Mm-hmm. Okay? And there's no reasoning behind it. So it's like they roll the dice. Up, roll a 6, can't have blue. That sort of thing. It feels arbitrary. It feels random. So give me an example of that. Your HOA says you can't use bricks in your backyard patio design. Okay? But when you ask why, their answer is, well, we just don't allow bricks. They can't give you an answer.
Right.
They can't articulate a reason. Okay? That tends to lean on the side of arbitrary. If they can't articulate a reason, and they owe you an explanation, well, we're going to learn later if they deny, whenever your plans are denied, they can't just say denied with a stamp. They got to explain why it's denied. So they got to tell you what's denied and why. So if they can't articulate it, then it's probably arbitrary. Okay? Well, we don't like bricks. Bricks are bad. Well, why? We just don't like bricks. That's circular.
And that's especially problematic with HOAs because these personalities on the board, they can inject ego and their own personal spin on it.
Right, and that's part of being arbitrary.
And that's arbitrary.
This director feels this way. That director on a different day might feel differently. That's the definition of arbitrary. Okay? So, architectural rules cannot be arbitrary. They cannot be unreasonable. And the last one is this word capricious. Okay? Something is capricious when the people making the rules keep changing their minds, or they act on sudden whims, or with the turning of the opinion tides.
Flip-flopping, yeah.
Flip-flop all over the place. Sometimes, for a period of time, these are in, and then they're out. And there's no reason for the switch. There's no okay, this happened, and we should rethink that. That's different, right? That's avoiding in for a penny, in for a pound kind of thing, right? So they're just whimsical decisions. That's what we mean by capricious. Now, a lot of capricious decisions are also arbitrary. So again, these do merge sometimes. Yep. But let me give you an example of that, okay? HOA approves it. Let's say you request, you want to put in brick pathway in your front yard, okay? A little pathway through your front. It's approved, okay? And then 3 weeks later, before you start construction, they change their minds. Now, we change our minds. We thought more about it. That's going to almost always be just capricious unless they can articulate a specific, reasonable reason why they change their minds. And that might not even be good enough. You'd want to come see us for that. But bottom line is they just flip-flop. They change their mind. It's whimsical. Or they go through periods of something is popular and then it's not popular. And then it's prohibited when it's not popular, that sort of thing. You can't, a neighborhood's aesthetic standard is somewhat objective. Okay, the neighborhood looks the way it looks. So if a certain number of homes have been allowed to do X, Y, or Z, then 2 years later, you can't argue, well, that's not within our aesthetic standard.
That's right, yeah.
That's what they look like. Sorry, you can't do that.
And ideally, you want a lot of those key tenets as far as the aesthetics of the harmony of that community to be articulated in those design guidelines or architectural guidelines.
That's right.
And if they fail to do so, guess what? They're kind of leaving it somewhat open to...
And when it's vague, it's going to often be capricious.
That's right.
Because they don't get they don't get the power that isn't given to them. So absent a statute saying this is how it is, or a specific rule or architectural guideline saying this is how it is, they don't just get to say, well, although this isn't really specified anywhere, this is how we think. No, that's when you come to us, because that is the definition of arbitrary and capricious. Sorry, if you want to control that, then you better get it in those guidelines. And it's not hard to do. 28-day notice period and comment period, pass the rule.
That's right. Yep.
Okay? So those are definitions. So let's be really, really basic. Unreasonable, too strict or unfair for the situation, for the set of given facts. Arbitrary, there's no real reason. It's just kind of made up. Capricious, rules or decisions flip-flop for no good reason, or they seem completely random. There's just nothing, okay? So with that out of the way, let's talk about what the statute then requires. So they can't be unreasonable, they can't be arbitrary, they can't be capricious. And, do you remember any of these off the top of your head?
Well, is it the timeliness of it? They have to...
We'll get to that. The review process has to be fair, reasonable, and expeditious.
Right.
That's what you're
the
talking
expeditious
about.
part, yeah.
Okay? They can't, and setting aside any specific provisions with a timeline that you might have in your architectural guidelines or your CC&Rs, set that aside just for a second. We'll cover it in a second. They can't sit on it for what's an unreasonable amount of time.
Right.
People want to use their property. They want to get things going. They don't want to live in a state of mid-construction type thing.
Or a state of limbo, yeah. I mean, you don't know what to expect.
That.
Yeah.
So they got to be fair, reasonable, and expeditious. Okay? The decision, when they make it, has to be in writing.
That's
Cannot
right.
be oral.
Yeah.
Okay? They can't announce it at a meeting. They can't call you on the phone. Okay? They have to put it in writing. And typically, I mean, technically, they could do it in an email, but they typically don't. They typically do it on the letterhead for the either the association or the management company. Okay? And then the request, if it's disapproved, they have to give you
The basis for it.
reason.
That's
right.
right. In
the
writing.
basis.
Yeah.
They have to explain why we rejected it. For example, you asked to plant eucalyptus trees. However, our design guidelines specifically prohibit, section 6.37b specifically prohibits eucalyptus trees. And they don't have to say this part. That's all they have to say. But they might add, and this rule exists because of the fire hazard.
And that's simple enough, straightforward. But
it should be.
It's shocking how many of them omit that part.
That's right. And here's the thing. If they can't do it, if they omit it because it's too hard, that means they're likely making stuff up. They're widely interpreting a vague power that's been given to them. Vagueness doesn't work in these guidelines. They have to be specific or it's not going to be enforceable. They can't just say, for example, when you build your walkways, the materials have to be acceptable to the board. No, I'm sorry, that's not going to fly. That's too vague. That gives the board way too much power. No, what is acceptable to the board? You tell us. Wood, cement, colored cement, what's prohibited, what's not, whatever you want to do, but you better specify it. Because if you don't, and you try to rely on, and a lot of CC&Rs and architectural guidelines have stuff like subject to board approval, No. You better be specific in those guidelines or rules about what is and isn't allowed. And if it's not stated, it's going to be allowed unless it's objectively a nuisance or interferes with somebody else's right. For example, if your HOA happens to protect views and they don't have a rule on the height of a shed, but your shed happens to will block a neighbor's view, they could say no, even though there's no rule that says sheds, you can have sheds up to this height and your shed fits there. They could still say no because it's violating somebody else's stated right. Okay? It's got to be found in the document somewhere. Otherwise, they can't do it. So this garbage that we see sometimes, especially with older documents, but this garbage we see about, walkways must fit a certain aesthetic standard approved by the board. That's not going to fly. I would challenge that in court any day of the week, and I'd be very confident in my chances. Okay? So here's what you want to check your governing documents for. Okay? For some HOAs governing, and by the way, this is that thing we were talking about. Some, and maybe probably newer ones in the last 15 years, maybe. Tell me if you agree it's more recent. And recent being 15 years. But a lot of governing documents that we see have a specific provision that says If you submit your
Oh.
plans for architectural approval and the HOA does not act on those plans within X number of days, it's going to be typically 30, 45, or 60 days. Typically, it'll be one of those three, but it could be something else. Then your plans are deemed automatically approved. Okay? If you have that language, great. That's good. I don't like the documents that don't have that language. So if they don't approve your plans or deny your plans within that period of time, whatever it is, then you're automatically approved, regardless of whether or not it violates the rules. Now, if it violates somebody else's rights, you're not off the hook. They could certainly come after you. But the board can't stop you for architectural or aesthetic standards. They could stop you for another reason, okay, if it's a nuisance or it violates somebody else's right. Or the neighbor, by the way, would have a direct claim against you. So just let's say you were trying to build a shed that blocked a protected view, and the HOA sat on it, and your guideline said 45 days, and the HOA sat on that, okay, and 48 days passes. It's deemed approved, so you go ahead and build your shed. You're not necessarily safe. The neighbor can come after you for blocking their view, okay? But the HOA can't make you remove the shed for the aesthetic reasons because they blew it. So if your HOA has something like that, you're good. Now, some HOAs, unfortunately, only go halfway. Have you seen this?
Yeah.
Where they say the HOA must reject or grant your proposal within 45 days. And that's the end of it. They don't say anything else. It's not automatically deemed approved at the end of that. It just means they're in violation when they didn't do it.
Yeah.
It's toothless.
And by the way, agreed as to the recency of that. I think that is something that you saw more and more widespread within the last 15, 20 years.
Yeah.
Yeah.
Yeah. And it's a good thing. HOA documents, typically in the CC&Rs, by the way, that's something that'll usually be in the CC&Rs as opposed to the architectural guidelines, or it'll be restated. But
we like those, yeah.
we
like
like
seeing
those
them, yeah.
because it gives us a tool.
Right.
We've got cases where we have definitive evidence that submitted plans were submitted, and then they calendar, let's say it was 45 days, day 46, they went and started construction, and then they did a cease and desist order from the lawyer, and the guy's like, homeowner's like, sorry, I submitted it, hand-delivered with a signed receipt on this date. I started building on day 46. You had 45 days. You didn't. It's accepted. And every time the HOA challenges that, they lose because they're wrong. Every time. It's delicious when they do that. I don't know why they do it because it's dumb. But anyway, look in your documents for that. If you have that, that's the first thing you're going to keep in the back of your head. You're going to calendar that deadline, 30, 45, 60, whatever it is, you're going to calendar it because the next day you're gold. Okay? Later, we'll talk about one of the dishonest tricks that HOAs try to do an end run around those. It's the old, it wasn't a completed application. Too bad, that won't work. We'll explain why later. Okay? So let's talk about the timeline process, but not what we were just talking about. Okay? So even if your HOA doesn't have a provision that says it's deemed automatically approved after the passage of a certain time, it's likely that at least your architectural guidelines will have a marker of some sort saying when you should expect to hear back.
Yeah.
And what do we think is the most common? What's it typically?
I mean, typically 30, 45 days. Or oftentimes you hear they'll convene at the next board meeting and I'll take this on. If they don't have an architecture committee or some other component.
Yeah, we should probably mention that.
Yeah.
Boards can, this is one of those things that boards can delegate to a committee, and the committee has to have at least a board member on it. Okay? I used to be on the architectural committee. When I've never been a board member because, trust me, I would never. I don't want to be. But I was on the architectural committee, and I think I count on one hand how many times I said no to something.
Nice.
I mean, if it was blatant, like if they were trying to build something, like you couldn't build it so it could be seen from the alley. If they were trying to build something that could be seen from the alley, we always said, hey, you got to lower it a bit. But my philosophy was, it's their house. Let them do whatever they want to their house as long as it doesn't affect anybody else. Who cares? Sometimes the architect would explain something to us, and we'd go, okay, we'll go with the architect. But it was usually something that was black and white, okay? And I was very proud of myself for that, and because I was making it easier for people to use their houses. You know, I didn't see my role. I saw my role as being a facilitator, not a stumbling block.
Right.
Which is the way it should be, by the way. It should be not, I'm going to use authority here. It should be, how can I let this guy or gal get what he or she wants with their house? What changes? Okay, maybe this isn't the right approach, but what can we do to suggest, okay, if you do this, it'll be fine. You know what I mean? Facilitate, don't impede, but that's not the norm.
Unfortunately, a lot of folks adopt the gatekeeper declining perspective on those things. Yeah,
they see themselves and their perspective and worldview is from the perspective as a gatekeeper as opposed to a facilitator.
That's right.
Facilitators don't get walked on. Facilitators facilitate.
Yeah.
They tweak and they say, let's do this to this to make it work. Yeah. Not, no, here's why. It's not the way to do it. But 30, 45, 60 days. Usually there'll be something in there saying this is when we need to act by. 90 days to me is too long, unless there's a reason. For example, let's say there's some municipal codes that actually apply, and the city sometimes takes a lot longer, and they've got to wait for that before they can act. Obviously, your HOA can't usurp the city's power. So, I mean, we've seen that
with
before.
Complicated projects, or if they, in good faith, want to bring someone out, a structural engineer, to look into things.
Right.
Yeah.
For safety purpose.
Exactly.
Or if the Coastal Commission, the California Coastal Commission is involved.
Yeah, that's
and
a good one.
Some of our beachfront communities, if the Coastal Commission is involved, it could extend the length of time on these things a lot, and it's not the fault of the HOA in those cases. But if whatever your guidelines say, or your CC&Rs, whichever the case is, then your HOA has to act within that time period. And if they don't, they are in violation. Okay? It's that simple. Hopefully, your documents have the or it's approved language, and then you're gold. Okay? Now, we've been hinting that these non-facilitators, these gatekeepers, that's often their view, their worldview. These board members who sit on these committees, or if the board handles it as a whole, they are into the denials. And often, those denials, because that's why we see them in our office, are unreasonable. And if they're unreasonable, that was one of the three things. Can't be unreasonable, can't be arbitrary, can't be capricious. If these denials are any of those, unreasonable, arbitrary, or capricious, then they're not enforceable. So, let's talk about unreasonable denials. Let's talk about what crosses the line and what are some red flags that you as a homeowner can look for to see if maybe what's happening to you is unreasonable, arbitrary, or capricious. Okay? Some denials are more than just unfair. Some denials are legally indefensible. It's a higher standard, right? I'll give you an example. No, we'll save that one. I'll save that. I don't want to jump ahead. Okay? So let's look at some red flags that may indicate whether your board or committee is acting improperly. See if you remember any of these. Denying a request based on aesthetic language that is so hopelessly vague that they can't actually, every board member will articulate it differently.
Oh, yeah. That's There's no uniform or consistent standard. It leaves too much room for subjective
Can you think of another word that we haven't said today that HOAs like to use? Just see off the top of your head. If we're on the same wavelength, probably not. He's not a mind reader.
Are you talking about the harmonious?
Yes.
Yeah.
You got it.
Oh, okay. All right.
You
nice.
got it. That's exactly the word.
Okay.
When you hear, unless it's backed up by, and here's why, and then they cite to something specific. When you hear, that's just not harmonious.
Does not comport with the harmony of
our neighborhood.
Yeah.
That is a red flag. Unless the word harmonious is quickly followed by, as is set forth in section blank. Okay.
That's right. Yeah. Yep.
That is a red flag because that is a buzzword for, I just feel like saying it. And this is my view of what our neighborhood's about. My opinion, Director A. Director B might see something as something else is inharmonious. And what I'm thinking, he thinks is harmonious. Okay? That's a red flag right there. Yeah. You're right on my wavelength. Another one would be imposing a restriction that is not written anywhere in the governing documents. All right, not just vague. Okay, not just it's really, really unstated, but it sort of falls under, like, for example, we talked before about you can't build a pathway made of materials that we don't approve. Right. Well, at least it's about pathways. But let's say they're talking about a handrail, and that's not even mentioned anywhere. So there's just no power given to them. Yeah. That's a red flag.
Yeah.
If they won't be able to cite to a document because it's not there. If they can't articulate where they're getting it and they're just kind of falling under this general harmonious thing, no, they can't do it. So if they're trying to impose a restriction that just isn't anywhere, no, they can't. Unless they can articulate that it's dangerous. Okay? If somebody wanted to, for example, I've never seen this, by the way, but it's an extreme example to make the point. Somebody wants to install an antique guillotine, a fully functional antique guillotine in their front yard. Okay? Well, no, kid could have his head chopped off, so no, we're not going to allow that.
Yeah.
Okay? I guarantee you governing doctors aren't going to say anything about a guillotine, but I understand why they would prohibit that. Now, I've never seen that, but I'm waiting.
That's awesome.
A third one, applying different standards to different homeowners. We call this selective enforcement. That's illegal.
Yeah.
Even if the underlying issue is reasonable.
Yeah. Yeah.
It might have even been enforceable at one point. It might have actually been specifically stated. Section 3.24H says no blue doors, but 7 of your neighbors have been approved for blue doors. No, they no longer can enforce that rule. Unless they make everybody paint their door. And good luck with that, because it's been, if they were approved previously, as opposed to just doing it and nobody did anything, whoosh, no. Understand? No, no, no. Selective enforcement is illegal, no matter how you play it.
Right.
Okay? Do you remember another one?
Let's see. They come in all these crossover variants, but
that's okay. I won't put you on the hook.
Yeah, I mean, we covered
denying a
the
request.
ones. Yeah.
Denying a request that complies with every published rule just because they don't like it. Okay?
Yeah.
So, in other words, you were very careful, you and your architect or whoever were very careful
Right.
to make the shed the right height, to make the wall the right height, to make your garage door that you want the right color and style, and but they just don't like the way yours is going to look, even though it's made of all the things that are approved. They don't like your taste. Nah, that's not going to work. If you've complied, even maliciously complied, that is, you stuck to the letter of the law, they can't, not on a harmonious or aesthetic standard. They can't go, well, you just have really bad taste, so we're going to hold that against you. No, sorry, can't do it.
Right.
Okay? So in many such denial cases, denial's actually, and this is when I was going to get into it, it's actually a pretext for something else.
That's right. Yeah.
Okay.
Yeah, that's common.
We talked, Sam mentioned ego before. Sam mentioned personality. That is a big factor in a lot of these decisions on bad HOAs. And what you see time and time and time again is these denials that are really pretexts because this person is a troublemaker or has criticized board members at open meetings or has sent emails about the things the HOA is doing wrong or has been otherwise a boat rocker, okay? And they find that their plans, they have to fight tooth and nail for what everybody else takes for granted.
Yeah.
You can't do that. The HOA can't do that. They don't get to play games. And they, even if what they're doing is technically correct, and I mean hyper-technically correct, if it is a pretext for a retaliatory, if it's retaliatory,
Right.
and it's mere pretext, it's not going to be allowed. Now, I don't mean that they might have hatred for this person. They might actually want to do pretext after pretext. But if the person's asking for something that they're not entitled to because it violates. It doesn't matter. You can get over the pretext by showing that there's a legitimate, completely objective, legitimate interest. I'm talking about those wobblers. And that's where you come into some of these bright lines that they cross, these selective enforcement issues.
Right.
If you can show that it's pretextual, or they make it more expensive for you, they deny a few times before they make you fight tooth and nail. They can't do that. You can hold them accountable for that. You can go after them for that.
Absolutely.
For the increased costs that you've incurred with your architect, with the city, with permitting, whatever, okay? They can't do it. Now, let's talk about a few really common tactics that boards use to get around all the stuff we talked about. So we just got finished with the red flags. We got finished before that with what the law says they can and can't do.
Right.
Okay? Now we talk about, well, I'm a board member and I want what I want. How do I get around that crap that gives homeowners rights? Because trust me, a lot of boards think this way. Okay? First one is the submission purgatory.
Oh, that's a big one. Yeah.
Okay?
Ugh.
You submit your request, and instead of approving or denying it, the board keeps asking for more.
Yeah.
Well, we're not really understanding what you mean. Please have your architect provide some additional drawings. Or, well, we don't really get what this is going to look like. Can you please give us some more details about this lighting thing or about this element that you want? What do you mean by that? How many are there? I mean, just they start moving the goalposts.
And with many of those, it's that state of limbo you're in with all these follow-ups. It's almost as if the clock gets reset each time they follow up.
In their mind, it does.
And then guess what? It's not that they're being responsive the next day. It's like, oh yeah, we'll
Right.
take it under
Let's
advisement.
say it's 30 days.
Yeah.
They wait till day 29, and then they send these things. And then you address it, and then they wait till day 28 or 29 or 30, and then they address it, but there's always something else they want. We need a little more of this, a little more of that. They make you spend money. This is on purpose, folks. Almost 99% of the time, it's on purpose. Sometimes we would send back. I told you a story when I was on the architecture committee. Let's say somebody wanted a shed, and the shed was, the wall height was 6.5 feet, and their shed was 6 3/4 feet. We might say shed's approved if you lower it to 6 and 6.5.
Yeah, conditional approval. Yeah.
Right, conditional approval. It'll go 1 inch below the height of the fence, and then we'll allow it. That's okay. I'm not seeking additional information there.
Right.
I'm telling them no right now. I'm not imposing some sort of unreasonable, time-wasting rationale there. I'm saying, as currently stated, no, but here's how to make it yes. Take care of it, and it's approved.
Small cure and move along. Yeah.
And now there's no purgatory there.
That's
the
right.
person does what they're told to do, and they can move forward.
Right.
This endless purgatory, that is a big
That's a
HOA
common one.
tool to absolutely screw with people.
I see
and
it all
violate
the
law
time.
every day. Shifting standards. Again, these last two, by the way, are going to be really close. Shifting standards. The HOA applies different rules from project to project, which gets into selective enforcement too. Because if you think about it, if on one project this was allowed and on another project that was allowed but that wasn't, well, that means some homeowners are going to have this, some homeowners are going to have that. The next person that comes along that wants this and the that's are in, it's not going to happen. So that's shifting standards. Again, that's part of the arbitrary and capriciousness.
Right.
The shifting winds and whims. No, it's not how it works. And the last one is related to the other two. They move the goalpost constantly.
Oh yeah.
Okay. We have a case now in way up north, like I had to think as north as you can get before you're no longer in California, like right there. Okay. And they kept moving the goalposts. First, they would demand that he comply with this, this, and that. So he did it. He spent the money. His architect redrew the plans. That costs money. They're paid by the hour. It's expensive. And then they go and say, yeah, but now we're like thinking this. And it kept happening. It kept like 4 or 5 times. Enough's enough. You can't do that. Okay? These aren't just problematic. They can all be legally challenged because by definition, those are unreasonable. Every one of those. So let's talk about what to do if you are denied. Okay? 1, if it's not already provided to you, which is required by law, demand in writing the exact reasons for every denial. If you have a big set of plans and your whole thing was denied, they can't just say denied and then list all the different things. They have to say your landscaping is denied and then your paint is denied, and they have to give you the reasons. If they don't, demand it in writing that they give you those reasons. Next, you want a copy, if you don't already have it, the latest copy of the most recent iteration, if there are more than one iteration, of the applicable guidelines or governing documents that were used in your denial. So you can read it for yourself and see if they're interpreting it correctly, because they might not be. Sometimes, more frequently than not, they're wrong. They just are. You want the names of the board members or committee members
Oh yeah.
that voted against and for,
That's important.
or who abstained, if any. Okay? If you're on the board and it's going over your plans, you abstained. So you weren't in the room. You shouldn't have been. Okay? You're entitled to know who voted yes and no. They can't say, "Oh, that's private. We don't want to take a stand for that." They can't do that. They have to tell you. Okay? And the last thing is whether the timeline specified in the document is expired. Calendar your dates. If you happen to have one of those provisions, that's the first thing you calendar, because the day after that deadline ends, if you don't have a definitive yes or no, you're in purgatory. Just do it. Okay? Now, you can also, if they either won't do any of those things or they do it and it's not to your satisfaction, you can request
IDR.
IDR.
Yeah.
Internal dispute resolution.
Right.
It's free. There's no lawyers involved. They have to, if you request it in writing, by law, the HOA has to engage. Now, you don't have to if you don't want to, but they have to if you want to. Or you could skip that, come right to the lawyer. Okay? So, bottom line, HOAs can certainly adopt architectural guidelines because it's almost certain that the governing documents authorize HOAs to do that. I've never seen governing documents that didn't, or I can't think of any off the top of my head. But in promulgating architectural guidelines and enforcing them as time goes on, HOAs are obligated under the Civil Code to apply those reasonably, non-capriciously, and non-arbitrarily. They cannot violate or deny what you want to do unless they have the authority to deny it. And that authority rests with the documents. And if it's not in there, they can't do it. So be vigilant, mark your calendars, read your documents so that your plans are as close to compatible and compliant as possible, which will significantly reduce the chance of being denied. And then if they still deny, then you might have a much easier time showing, for example, that it's a mere pretext, that they're trying to get back at you, or they're selectively enforcing against you, which is illegal. But be wary. You've got to be in compliance with what's in the documents. But once you are, the HOA has to comply, and they can't be unfair, okay? If you like this episode, please hit the like button and be sure to subscribe to the channel if you haven't already done so, HOA HELL. As always, we love to hear from our listeners, so if you want to leave a comment, please do so. And until next time, have a wonderful day.